If a will leaves a gift to someone who ends up dying before the testator, the gift lapses, meaning it becomes part of the testator's undevised or residuary estate. However, lapse won't occur if the will names an alternate beneficiary or if an anti-lapse statute applies. A California court explored the interplay between an anti-lapse statute and a will's unnamed heir exclusionary provision in Estate of Tolman versus Jennings. Nellie Tolman's will bequeathed $10,000 to each of her granddaughters, Deborah Tomlinson and Laurie Onan. The will stipulated that each of these gifts would lapse if Tomlinson or Onan died before Tolman. The will bequeathed the rest of Tolman's estate to her daughter, Betty Jo Miller, but didn't state that the gift would lapse if Miller predeceased Tolman. In addition, the will contained a paragraph stating that Tolman intentionally omitted to provide for any of her heirs not named in the will. By the time Tolman passed away, Miller was already deceased. Consequently, under California's anti-lapse statute, the gift devised to Miller would go to Miller's lineal descendants, her son, Michael Jennings, and her 3 grandchildren. However, Tomlinson filed a petition to determine persons entitled to distribution. Tomlinson alleged that the will's unnamed heir exclusionary provision defeated the anti-lapse statute and barred Miller's grandchildren and Jennings from inheriting because they were Tolman's legal heirs and not named in the will. Jennings argued that, under the anti-lapse statute, he and Miller's grandchildren were entitled to inherit, not in their role as Tolman's heirs, but as lineal descendants of Miller, a predeceased named beneficiary. The trial court found that the will's unnamed heir provision wasn't specific enough to defeat the anti-lapse statute. Thus, the trial court denied Tomlinson's petition and declared that Tolman's gift to Miller passed to Miller's descendants pursuant to the anti-lapse statute. Tomlinson appealed to the California Court of Appeal.